Good morning, Madam Deputy Registrar. Would you please call the matter?
Good morning, President. Caribbean Court of Justice, original jurisdiction, hearing of application in TTN OJ number 1 of 2025 between Mike Daniel Bhagwansingh and the state of Trinidad and Tobago. The members of this morning's panel are Mr. Justice Anderson, President, and the presiding judge.
Good morning, everyone.
Madam Justice Rajnos Lee.
Good morning, everyone.
And Mr. Justice Barrow.
Good morning to all.
May we have the appearances, please? Thank you.
Bhagwansingh representing himself as the applicant.
Sorry, we didn't quite hear you, Mr. Bhagwansingh. Would you want to repeat?
Sure. Good morning, Your Honor. Mike Daniel Bhagwansingh representing himself as the applicant.
Yeah, thank you, sir.
Welcome.
Your Honors, my name is Sanjit Lala, and I'm appearing here with Mr. Puja Maraj on behalf of the state of Trinidad and Tobago, and I'm instructed by Ms. Claire Thomas Medina.
Thank you, Mr. Lala. And good morning again. We're, of course, here to hear the application for special leave pursuant to Article 222 of the revised treaty application having been brought by Mr. Bhagwansingh. Are you prepared to proceed, Mr. Bhagwansingh?
Yes, Your Honor.
Yes. Okay. So I wondered whether you could help us by cutting to the chase, so to speak. Can you identify for us the precise right which you say was intended for your benefit and which was prejudiced by the actions of the government of Trinidad and Tobago, the respondent? As you know, under Article 222, the first condition to be satisfied for the grant of leave is that you should indicate a right intended for your benefit under the treaty. So can you help us to locate the right that you have in mind?
Your Honor, to begin, the crux of the case is that by requiring persons to have a banking license under the Financial Institutions Act, the state of Trinidad and Tobago has breached its obligations under the revised Treaty of Chaguaramas with respect to the right to provide financial services. So the particular right...
Go ahead, please, yes.
The right that the applicant wishes the court to declare is the right to provide commercial banking services, which is corollary to the right to provide financial services.
Right. So can you point us to the passage in the treaty that provides you with that right?
The right to provide financial services, Your Honor?
The right that you're claiming leave to pursue in substantive proceedings.
The right to provide financial services would be based on Article 46(1) in combination with Article 38(1).
So where in 46(1) does it provide for the right to provide financial services?
It does not explicitly accord the right to provide financial services, but it states that without prejudice to the rights recognized in the state in Articles 32, 33, 37, 38, and 40. So by stating that rights are recognized and agreed to be accorded to the member states in particularly Article 38(1), and having read Article 38.1, which states that subject to the provisions of this chapter, member states shall remove discriminatory restrictions on banking, insurance, and other financial services. It can be interpreted and implied that Article 38.1 accords the applicant the right to provide financial services, which is recognized by the member state.
The 38.1 speaks about the obligation on member states to remove discriminatory restrictions. Is that what you're referring to?
Yes, Your Honor. Correlative to that obligation is the right to provide financial services.
Right. Now, when we talk about discriminatory restrictions, are you able to point us to what you have in mind? What is discriminatory about the restrictions in Trinidad and Tobago, which would breach 38 in your view?
Essentially, it will be the applicability of the license to the applicant, because the treaty guarantees and accords CARICOM nationals specific rights as well as obligations for member states, corresponding obligations for member states. Could you repeat the question, Your Honor, please?
No. I was just wondering, where would you locate the discriminatory restrictions that you say impede your right to provide financial services? Is there something in is it the Financial Institutions Act which contain that discrimination?
Right. So the treaty accords CARICOM nationals specific rights, and member states have corresponding obligations to those rights.
Well, could we pause here for a moment? Where do you see that the treaty accords CARICOM nationals these specific rights? Are CARICOM nationals parties to the treaty?
As beneficiaries, yes, Your Honor, to benefit from the rights granted by the treaty.
No. I'm asking if they are participants to the treaty. Are they parties to the treaty? I thought the treaty was between and amongst the member states of CARICOM.
As well,
there's a basic rule in international law that a treaty does not create obligations or confer rights on non-parties. And I do not believe that any CARICOM national is a party to the RTC. It's an interstate treaty agreement, as far as I can recall.
Mr. Bhagwansingh, the president has been working, I think, very closely with you in trying to evoke what your rights are. And if I may step in here to relieve him perhaps a bit of the carriage, I think what is troubling me, and I dare say maybe troubling others, is we understand what it is you want to do. But I think what the president is asking you is, in relation to the treaty, how is it that the treaty is being invoked by you to enable you, in relation to your own country, to do what you want to do in your own country? So this is not that, it is not like you are a member of a national of another country, and the state of Trinidad is discriminating against you as a national of another country. It is that you, as a national of Trinidad, want to do something in your state, and your state is saying, these are the obstacles or the hurdles or whatever it is to your doing this. So what I would like you to assist me with, and I think the president is asking, where in the treaty are you entitled under the treaty to make this claim? I hope that helps.
Well, Your Honor, the right is not directly expressed in the treaty. It is based on my interpretation of the articles in combination with each other, Article 46.1 and 38.1. And from that, I derive the right to provide financial services and the state's correlative obligation to remove discriminatory restrictions on the provision of the service, commercial banking service.
Yes, but of course, you're coming to us under 222, Article 222 of the RTC. And the first condition, as we said earlier, is that you have to demonstrate that a right was intended for your benefit, and that right has been prejudiced. Second condition. Now, the first condition says that the court, that's us, must determine in any particular case that this treaty intended a right or benefit conferred by or under this treaty on a contracting party. So the right that you're seeking to espouse is not conferred on you. It is conferred on the contracting party to the treaty, in this case, Trinidad and Tobago. And having been so conferred, we must be convinced that that right was intended to inure to the benefit of such persons directly, i.e. to you, as a national of Trinidad and Tobago. So the right is invested in Trinidad and Tobago, and then we find that it was intended to inure to your benefit. It seems to me that what you're trying to argue is that the right in Trinidad and Tobago has somehow been transmuted into an obligation on Trinidad and Tobago vis-a-vis you as a national of that state. And I'm having difficulties understanding how that works. As my brother said, if you were a national of another country, let us say of Barbados, Trinidad, of course, would have a corresponding obligation. Barbados would have the right. Both are contracting parties to the treaty. And then Barbados could espouse the claim on your behalf that you're being unfairly treated by the state of Trinidad and Tobago. Or if Barbados chose not to do so, then Barbados could allow you as an individual under 222 to expose the right. I'm clear on that. But what I'm not clear on is how you, as a national of Trinidad and Tobago, can claim against your state in Trinidad and Tobago in respect of a right that only comes to you through the agency of your state.
Understood, Your Honor. But from another perspective, if the state of Trinidad and Tobago has the right to provide financial services,
Sorry, I'm not
commercial
hearing you
banking
clearly.
services,
I'm not hearing you clearly. You said if the state of Trinidad and Tobago has the right
to provide financial services and by extension the right to provide commercial banking services, and the applicant can essentially basically receive those services provided by the state, then the applicant also has the right to provide those services corollary to the state to receiving the services provided by the state on a commercial basis.
Mr. Bhagwansingh, perhaps I could ask the question a little different way. You're relying on Article 38, and I believe President had before us this question, because the obligation on the member state is to remove discriminatory restrictions, which would suggest discrimination under Article 7 on the basis of nationality only. So I'm trying to understand then what you say the state has, what right you have what discriminatory practices you want to highlight that you say are contrary to your rights under the treaty. Trying to understand how you see that working.
The discriminatory aspect of Section 16.3 would be the
16.3 or
The
of the
38?
Financial Institutions Act.
Oh,
sorry.
16.3,
Yeah.
I see.
The discriminatory aspect of Section 16.3 of the Financial Institutions Act would be that there is no, in my view, preferential treatment accorded to, in this case, me.
No
Because,
preferential treatment accorded to you?
or any other CARICOM national who has, by extension, or nationals of Trinidad and Tobago who can benefit from espousing and exercising the right in question. So the applicability of the license to myself in this case would be the discriminatory restriction, as the license is a restriction and the non-accordance of preferential treatment would be the discriminatory aspect of the applicability of the license to the applicant, myself.
President, if I may,
Yes.
may I ask Mr. Bhagwansingh, how does that involve the treaty? How does that involve the treaty in the sense that if there are discriminatory elements in the legislation, that applies to all who come within the purview of the legislation? That has nothing to do with the treaty. So any person, any entity seeking a license is met by the requirements of the legislation. That's an entirely national matter. So how does that have anything to do with the treaty? You must forgive me, Mr. Bhagwansingh, but it is a major hurdle that I need you to help me cross in my thinking. So how does that have anything to do with the treaty?
In my respectful view, Your Honor, the obligation imposed on the member state by Article 38.1 has a correlative right that inures to the applicant, in this case, which would be myself, and the right to provide financial
Well, I
services.
think I need to stop you there because you have been repeating this. And the obligations imposed upon a member state, the correlative right is in relation to another state. It is not a correlative right given to a national of the state which is claiming the benefit of the right. And where the president indicated, if it were the case that there were two states involved and one state is not affording the rights which the treaty says should be afforded, then the state who is being denied or the national of that state, provided certain conditions are met, could invoke under the treaty the right. But that is not the case here, and I am very sorry to be repeating myself, but I do not understand how you get into the treaty for yourself. How Trinidad can exercise a right against itself. Help me, please.
And I came to that understanding
Sorry,
based
I'm
on
not hearing
reading
you.
Article 40.
Sorry, could you repeat? I did not hear you
Sorry, Your
clearly.
Honor. Sure.
Yeah.
I came to that understanding based on reading Article 46.1, which states that without prejudice to the rights recognized and agreed to be accorded by member states in Articles 32, 33, 37, 38, and 40 among themselves and to community nationals. So that would imply that community nationals were also accorded rights under Article 38.1, which were recognized and agreed to be accorded to them by the respective member states.
But Mr. Bhagwansingh, this is rights afforded to community nationals of other states in relation to a given state. You, in relation to Trinidad, you are not a community national. You are a national of Trinidad and Tobago.
You can have specific rights, of course, recognized by the treaty, vested in private persons. So you do have examples of this in Article 46, where it speaks about university graduates, media workers. These are specific persons, and I imagine that they could, in fact, bring, on the basis of the express conferment on them of these rights, an action to protect those rights, as my brother says, provided they satisfy the conditions in 222. But when we come to speak of correlative rights, I think we're in a different category altogether. And I am not persuaded so far that as a national of the state, enjoying the right, that you can, by some magical wand, convert the right in your state into an obligation by your state towards you. I would have thought that the easier way for you to go is that if you thought that there was some discrimination, that you could quite easily bring an action within the national courts, say judicial review or constitutional breach or something like that. But as the questions I think which are being asked are suggesting, it's difficult to see how you are going to pull yourself up by your bootstraps and bring this into the regional court. It's a difficulty we're really having with the application. You see, a part of this too goes back to what I believe the respondent, potential defendants, argue that you did not receive the green light from the government of Trinidad and Tobago to bring this application or bring this claim. Now, that in itself also is instructive, because 222, in the section dealing with the right of the state to espouse the claim on behalf of its nationals, makes clear that it is really the state in whom the action is vested. And it can, and in the normal course of events, should pursue the claim on behalf of its national. There are certain circumstances where, as our brother said, provided certain conditions are met, the individual can also pursue the claim. But I don't want you to lose sight of the fundamental point that the right to bring the action is vested in the contracting state enjoying the right. So that it becomes, again, very difficult to understand how a national of that state can in some way override the vesting of the right to bring the action in the state by suing the state itself. To me, it is a little difficult to understand. I don't know whether you could help us on that point as well, which was raised by the respondent in its submissions.
Understood, Your Honor, but the rights I'm claiming is premised on Article 38.1 in conjunction with 46.1. So based on my understanding of what Your Honor said, there is no right accruing to me as a national, as a community national in Trinidad and Tobago.
I wouldn't say that. I would say that there could be, we haven't examined the issue yet, but there could be such a right accruing to you through the government of Trinidad and Tobago. And that right could be vindicated by an action against any other member state that is seen, in a participating member state, that is seen to be breaching the right. There's no difficulty there. The difficulty we're having is whether you can actually pursue what you consider to be the right against the entity through whom you got that right.
My understanding, Your Honor, if I was suing another, or if I were interested in suing another member state for breach of
You're breaking up again, Mr. Bhagwansingh.
then
Sorry.
my apologies, Your Honor. To my understanding, if I were to sue another member state other than Trinidad and Tobago for breaching my alleged rights under the treaty, then I would have to approach Trinidad and Tobago to pursue the case on my behalf and give them the opportunity to pursue it or allow me to pursue it in my own. But if it is the member state that is breaching the right of the national, ask them if they would be willing to pursue the action, because more than likely they will not. So the burden will be about the
But that
opportunity.
illustrates, Mr. Bhagwansingh, the very difficulty at the root of the argument. That is the problem, because we cannot ignore the wording of the treaty. The treaty says very, very clearly that the contracting party entitled to espouse the claim before the court can do so or can allow its national to do so. What you are saying is that your hypothesis of the case allows us to simply ignore condition 22C of the treaty.
And if
So it may be then that your hypothesis of the case is the problem.
Your Honor, I do not have it on hand, but I'm sure I read in a judgment that if a national will pursue a matter against its own member state, that particular requirement would be waived. I could be wrong, but I'm sure
what power, assuming that you are correct, what power gives the court to waive provision in the treaty?
Because approaching the member state to ask them if they would.
No, I'm not talking about logic. I'm talking about what power in this treaty gives this court the authority to ignore the clear wording of the treaty.
It was based on a judgment I read, Your Honor. I do not have it on hand right now, but it was based on a judgment which would be an extension of the treaty.
Okay. Thanks. Did you want to offer anything else in support of your application?
Sure, Your Honor. In fact, I could research for the judgment and that states.
You're breaking up, sir.
Approaching the state.
Sorry, could you repeat? You were breaking up.
Sure. If I'm given the opportunity by the court, I will get the judgment which states that you'll approach the state directly without having to which I could.
Yes, Mr. Bhagwansingh, I'm sorry, it doesn't work like that. We have a date for the hearing of this application. You have to do your legal research, get your submissions in order, provide your authorities that you intend to rely on, so we can consider them. We can't do the case in installments. So I'm afraid that we're not going to countenance you're doing additional research. You can understand the problem, because the next time we meet, maybe the other side might want to do further research as well, and then we'll never end. Yes. Yeah. So one of the things to bear in mind is that when you come to court, you have to come with all of your arguments finally marshaled and ready to be presented. Is there anything else you want to press on us?
Press, before Mr. Bhagwansingh goes on, if he chooses, I wonder if Mr. Bhagwansingh can assist me, and this is not imposing any obligation on you to provide information, but the thought occurred to me that this may be, as the president indicated, an area, a denial that you claim is being imposed upon you, where a remedy within the structure of the domestic legal and judicial system is called for, so that if the law discriminates against you, if the law is in any way bad as far as you're concerned, then the president did mention the option of a constitutional law claim or a judicial review claim. And I just want to wonder whether there was something which made you not go that route. It is quite frankly a collateral or incidental question, but it just may help me clarify my thinking. Thank you.
Your Honor, it was just based on my interpretation of the treaty, and that's it.
No, but you went straight to the treaty. What you were faced with was a law. So why challenge the law? Why challenge the, as you regarded the hurdle put on you, the requirement for a license? Why go under the treaty instead of going against the law?
Because in my opinion, Your Honor, the laws of the national state must be in conformity with the obligations and rights, well, the obligations of member states and the rights of community nationals under the treaty.
Mr. Bhagwansingh, you need to work with me here. The laws of a member state must fundamentally be in conformity with the Constitution. So your fundamental right in relation as a national is under the Constitution. This court is subject to your Constitution. The treaty is subject to your Constitution. So I'm just curious, but it seems to me that thought simply did not occur to you. Is that correct?
Possibly, Your Honor, but my understanding is also that the treaty is the constitution of CARICOM as a whole.
I leave it there. Thank you.
Okay, Mr. Bhagwansingh, anything further?
Not at this time, Your Honor.
Okay, well, I do think you have a right of reply, so that we may hear from you a little later if you think that necessary. Respondent, Mr. Lala, any views here?
Thank you. Thank you, Your Honors. No, please note, I believe we have addressed all the concerns that Your Lordships, so Your Honors have raised with Mr. Bhagwansingh. We do believe that the application is misconceived. I do believe that it's something that should be addressed in a different forum, Your Honor. I don't believe it is one that should be before the court, the CCJ. And we rely entirely on our submissions in response to the application that's before the court. We had identified that I believe if my friend is claiming a discrimination, then that is something that the local courts can fully address and ventilate. He's challenging the Financial Institutions Act and a provision there, which I believe, if I understand my friend is saying, is that it's prejudicial or discriminatory, and that is something that the local courts can address in the proper form and the proper manner. But I respectfully, my lord, we are of the view, sorry, that this matter should not proceed. I don't believe my friend has made out or satisfy the requirements under Article 222, and that especially ought not to be granted in this case. Unless it's something troubling, Your Lordship, Your Honors, I don't really wish to add anything further than what I have filed in our submissions. Unless there's something that's troubling panel, of course.
Yeah, thank you. My colleagues, I do not see my colleagues wishing to delay you.
I am untroubled, President. Thank you.
Yes. President, there's only one matter that I
Sure.
wish to raise with Mr. Lala, and it relates to costs.
Yes.
Yes, Mr. Lala, we do not see anything in your submissions or anywhere else where you seek costs. Are we right about that, or?
That is correct. Your Honor, I have not addressed the issue of costs. in the circumstances, and having looked at the claim itself, I'm entirely in the court's hands. I do not have permission, regrettably, to consent to any particular position on the matter, but I am prepared to leave the court's hands on that issue. And if it is that the court should order that the parties bear their own costs, I don't think that's entirely objectionable. Unfortunately, I just simply cannot consent to a cost order at the moment, unfortunately.
Thank you very much.
Yeah, thank you. I'm not sure that Mr. Lala said anything that you have a right to respond to. He simply referenced the written submissions that he had provided. So are you satisfied to rest on the written and oral submissions, Mr. Bhagwansingh?
Yes, John.
Yes. Thank you very much. Okay. Well, would you permit us just a few minutes to confer? Might take more than a few minutes or less, we'll see, and then we'll be back with you. Please hold on. You can take off your cameras if you wish, but please stay on the line. Thank you very much.
Justice Barry, you're still with us, so please don't say anything. I think they're trying to get you in.
What did happen here now? Oops. Madam Deputy Registrar, are we free to resume?
I am not. I'm still seeing Justice Barrow on hold. Jacob, would you be able to bring him back in with us?
Yes, Deputy Registrar, I'll call him in.
Thank you. President, I think Justice Barrow just fell off the meeting. He's upstairs. Let me see whether I can maybe call to see what's happening with him.
Okay. I think our brother
Justice
might be
Barrow,
back.
Justice Barrow, are you there with us? We're not seeing you.
Oh.
You're on mute.
Yeah.
You're muted, Judge.
Yes, I'm happy to be here. Thanks. Sorry about the hiccup.
Yes. Okay.
Yeah.
President, you can resume. Thank you.
Thank you. Thank you all. So we have considered the application for special leave under Article 222 of the RTC. We have considered both the written and oral submissions of the parties, and we have decided that the application will be refused. We intend to provide written reasons for the refusal, which will be available in due course. Naturally, a corollary to the refusal of the application is the refusal of the application to be heard by video. Finally, we will award costs to the respondent, as is the norm in these kinds of proceedings with this kind of result. We do bear in mind, however, Mr. Lala, that you have made certain representations which suggest to us that you would not be eager to pursue your rights on the cost order. We're not making an order on that impression, but we are simply observing the remarks you made earlier. We suggest to us that perhaps you would not pursue your rights there. We're not making any requirements of you in that regard, however. Any comments from the parties?
No,
I
please, Your
would
Honor.
like to hear from you, Mr. Lala.
Well, Your Honor, on the issue of costs, I understand and I accept that the normal practice would be that the successful party is entitled to their costs. The concern that I had, I mean, not have articulated it very clearly or properly, but the claimant being self-represented, I am uncertain whether the court may have a particular view especially in fact, and in light of the fact that the application has been refused, how the court would prefer to treat with such matters. My limited experience, Your Honor, is that normally, for example, when we deal with judicial review applications in domestic courts on a leave application for judicial review, and it's refused, normally the parties bear their own costs. And that was operating in my mind in the sense that this is a leave application and that it has been refused. And I would figure that the court may want to adopt a similar approach. What I was hesitant to say is that if the court was to ask that we don't insist on our costs, unfortunately, Your Honor, I don't have the authority to consent to that. But if that's the court's view on the matter, given all the circumstances, that I'll be bound or abide by that finding of the court on that issue.
Yes, the court has expressed its view on the issue. In fact, the court has given a decision on the issue. It's entirely a matter for you and your client to decide whether you will pursue the matter. We have ruled in accordance with what we consider to be appropriate.
President, I cannot contain myself. I must simply express my regret that we did not have the benefit of this exposition by counsel for the respondent in relation to costs before we made our deliberation in relation to it. That is all. Thank you.
Sorry, Your Honor, I apologize.
Mm-hmm. Thank you. Anything from you, Mr. Bhagwansingh?
Nothing further from me, Your Honor.
Yeah. Well, thank you very much, everyone. This brings us to the end of our proceedings. Madam Deputy Registrar.
Thank you so much, President Anderson. Thank you, Madam Justice Rajnathi. Thank you, Mr. Justice Barrow. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.